Get ready. 3, 2, 1, start. The state has therefore filed this appeal. The Learned Counsel for the state submitted that the view taken by the tribunal that only the disciplinary authority can initiate a departmental proceeding against the delinquent government servant is contrary to the law laid down by this court. This point is covered by the decision of this court, and therefore the contrary finding recorded by the tribunal will have to be set aside. The Learned Counsel for the respondent has fairly conceded this position. The view taken by the tribunal as regards the effect of non-furnishing a copy of the inquiry office is also contrary to the law declared by this court. In this case, the order of dismissal was passed, therefore, the tribunal could not have nullified the order of dismissal in view of the judgments of this court. The third reason given by the tribunal that there was no justification for initiating a disciplinary proceeding against the respondent is also not sustainable. The proceeding was initiated against the respondent for his indisciplined conduct in disobeying a lawful order passed by his superior officer who was competent to pass such an order. The respondent was transferred and was posted as sub-inspector in charge of the police station. After joining duty there, he proceeded on leave and continuously remained on leave till he was called upon by the superintendent of police by passing an order to appeal before the medical board. As he was remaining absent on medical grounds and had produced certificates from different medical officers, the commissioner of police, becoming suspicious about the genuineness of the ground on which he was remaining absent, had passed that order. The fact that he did not comply with that order is not disputed. His explanation that he had no money to travel and therefore he had requested the commissioner of police to issue a railway warrant, and as a railway warrant was not given to him, he could not remain present before the medical board as directed, was not accepted by the concerned authorities. We will hereafter point out that there were good reasons for the authorities not to accept the said explanation. Such an act of insubordination or disobedience of an order by a police officer has to be viewed seriously, as higher degree of discipline is expected of a member belonging to the police force. Therefore, it cannot be said that there was no good and sufficient reason or a valid justification for initiating the disciplinary proceedings against him. What was, however, contended on behalf of the respondent was that, in absence of any rule treating non-compliance with an order, stop.